Welcome back, everybody, to contract law. This lesson is going to start talking about the next major topic within the subject of contract law. We've spent quite a lot of time talking about the creation of contracts, talking about the various requirements that are necessary for the creation of a contract. We talked about the creation through an agreement, which is represented as offering versus accepting. We then talked about an intention to create legal relations. And then finally, we focused on the question of consideration and promissory estoppel. This lesson is going to start talking about terms of a contract, the idea of contractual terms and their importance within the broader conversation that we have about contract law. So this is the next major topic within our series on the law of contracts. And it is going to focus on the actual specific terms of a contract, the kinds of things that are actually written in the contract. So we're moving beyond their creation and whether or not contracts even exist in certain circumstances owing to various different factors. And we're going to start to talk about what actually exists in contracts that we know exists. So we know that the contract exists. We have solved the question as to whether or not there is a created contract here, because we've looked at all of the conditions required for the creation of a contract. Now we're looking at what the contract itself actually says. So this refers to not only the content in terms of specific contractual terms, contractual provisions, but also in terms of the structure of a contract. The vast majority of terms within a contract are actually expressly stated in the contract. So if a contract is established, a written contract that requires the performance of a particular action, well then, if that is expressly stated in the contract, that just means that we see it written down as a term of a contract. Clause 3 tells us that we have to do this performance in order to fulfill our obligations under a contract, for example. There may also, however, be terms which are implied into the contract, which don't necessarily have their own explicit clause, which requires you to actually be able to just read it and see what is to be done, but more so are by the nature of the contract or by the nature of the obligation implied into the agreement. It may also be the case that, while in a period of negotiation for a contract, a number of things which were stated could be potentially terms that end up being incorporated into the contract, but also may not be terms, and so are not incorporated sufficiently into the contract either. So it is important, as a result of all of this, to begin talking about the pre-contract stage, i.e. the negotiation stage, before the contract is actually formally agreed upon, to see the kind of things that could be negotiated into a contract. And the first thing I want to just make a reference to here is this idea of puffs. Puffs are the weakest form of statements which are made in the negotiation / the sort of pre-contract stage of an agreement. And what they essentially mean is they have no fulfillment if they turn out to be false, and there is no liability incurred to an individual charged with making it. They are just simple statements that are made that essentially have very little meaning, okay? And so you cannot rely on such statements to enforce contractual obligations against individuals. These are most often found, in fact, in advertising circumstances to boast at the quality or the performance of a good or service, but do not carry with them any kind of legal obligation. For example, when Red Bull sell you their energy drinks, they will say Red Bull gives you wings. Now, you could not, as a result of reading that slogan, that advertising slogan, sue Red Bull on the basis that they didn't give you wings, because that is not what it's not a term of a contract. It is simply a puff, a weak form of statement, which is made in often the pre-contract stage. So yeah, it doesn't actually give you wings. In fact, in my opinion, they're not very nice, Red Bulls. So next we have representations. A representation is a slightly stronger form of statement, and a representation is defined as a statement which is made, which is not and does not form part of a contract itself, but instead will induce an individual to enter into a contract. So we delineate this from, if we go back to the previous example of Red Bull gives you wings, this cannot be a representation, because the concept that Red Bull gives you wings probably did not induce people into going into and entering into a contract. They're a little bit more serious if they are false or if they are not fulfilled in terms of their obligations. If a representation is made about a product which turns out to be false, then people have entered into the contract on the false premises. So essentially, for example, you could make a representation about the quality of a product, and so if that and then if obviously taken from a positive point of view, if it is therefore concluded that the person is going to create a contract or enter into a contract with you on the basis of that quality assessment, and then it turns out that the quality is actually not what the assessment said it was, then this again would represent quite a serious representation, or at least an invalid representation, which, because of the idea here, is that fundamentally, if you are falling into a contract because of a thing that was said, a representation that was made, then it turns out that representation is false, then you have entered into a contract under false pretenses. And so the most important liability will be for misrepresentation in this area of the law, something we'll get to in future lessons' time. Finally, then, we can think about terms. Terms are simply part of the contract itself. They're not simple, catchy slogans which have very little, if any, value at all in contract law. They're not representations. They don't induce a person to enter into a contract. They are the terms of the contract. An inducement has already been made. People have already entered into the contract, or at least have a desire to enter into the contract. And now we have the inducement into the contract. It will often be expressly stated as a clause within a contract, a term would be, and will make a pledge to do something or perform some kind of undertaking. Where a term is reneged upon, where terms are not followed, okay, the injured party has the opportunity to sue, because at this point they've breached their contract. If you breach the terms, if you fail to perform your obligations under a term, then you can be sued for breach. Now, whether or not the claimant would be successful in that case would depend, of course, on whether or not you had a valid reason to breach your contractual obligation, in which case there might be a reduction in damages. But for now, just note that a term would actually, if reneged upon, cause the opportunity for an individual to breach the contract.